privacy policy or privacy notice? This one seems to run and run, but does it matter? Why is this even a discussion? We'll give you the answers in less time than it takes to drink a coffee. We'll look at GDPR itself, we'll look at European regulators, and stick with us, we'll look at private sector practice and even standards bodies. Hi, I'm Robert Bohr, the founder and CEO of Keepabl, the award-winning privacy management software saving you time, money and stress on privacy, giving you a great answer for the board, auditors and customers alike. This video is part of Privacy Kitchen, free video help with GDPR and all things privacy. If you're new here, please do click subscribe and notify to hear about awesome new Privacy Kitchen videos. As always, links are in the notes below. And we'll just say GDPR again in this video because the EU and UK GDPRs are the same here as at July 2022. Right, grab a cup of coffee and let's crack on. I'll open with the answer straight away. Nowhere in UK or EU data protection law is it written that you have to call any document a privacy policy or a privacy notice. GDPR doesn't even use the term notice. It's fake news. This distinction of internal and external simply does not exist in the world of GDPR and data protection law in the UK and Europe. As we'll see, it's the obligation to give information, and that applies as much to data subjects who are employees or internal as customers, external. The bottom line is there's no legal rule in this, in privacy law. The important thing is you provide data subjects with the information you're meant to, when you're meant to. Now, the dominant practice historically has been to call the document on your website privacy policy, and I'll show you the proof from regulators. But calling it notice is totally fine too. Now, if you don't like this, you can check out our refund policy. Notice. I'm joking, this is free. Okay, so not only does the term privacy notice not appear in GDPR ever, the word notice only appears once in GDPR. Recital 103 is about when the Commission can give notice to revoke an adequacy decision. That's it. Doesn't appear in the articles. And here's the relevant parts of Articles 13 and 14 from GDPR. No reference to the word notice at all. It's all about giving information. That might surprise people. Article 12 of GDPR goes into transparency of the information to be given. Doesn't use the word notice either. Again, it doesn't appear in GDPR apart from that one recital on something else. And this is the same in Articles 10 and 11 in the 1995 EU Data Protection Directive before GDPR, which is basically identical. The word notice didn't appear at all. Zero in the 95 Data Protection Directive, not even in a recital. And as to UK law, the word notice isn't used in this sense in any of the 1984, 1998 or 2018 UK Data Protection Acts. Now, the word notice does appear 417 times in a 2018 UK DPA, and I've looked at everyone to check, it's all about enforcement notices or penalty notices. It's not about the information to be given to the data subject under Articles 13 and 14 of GDPR. So we've established nowhere in UK or EU law does it say you have to use privacy policy or privacy notice at all. It doesn't use the word notice itself, it just says give this information to the data subject. Right, so you're free to call the document whatever you want. That's the legal situation. Let's look at what the UK and EU regulators use, starting with the UK regulator, the ICO. Now, back in 1995, according to the Wayback Machine, the UK ICO itself just had privacy for this in the website footer, and it linked to a document they themselves called a privacy policy. And in 2007, they changed to use privacy statement in their footer, which still linked to a document they themselves called a privacy policy. Now today, July 22, post-GDPR, the UK ICO uses privacy notice in its footer, and that does link to a document they call a privacy notice. So the UK ICO used policy for decades and then switched to notice after GDPR. Absolutely fine, but they didn't need to. Now looking at EU regulators, starting with the French regulator CNIL. CNIL uses, excuse my French, données personnelles or personal data in their footer. This links to what they call their politique de protection de données or data protection policy. Now, privacy policy is also used by the Danish DPA, the Norwegian DPA, the Spanish DPA, the Polish DPA. Now, the Romanian authority uses cookie policy and information on processing, which then refers itself to a policy. I stopped at that point. It all seems pretty clear because do all these national DPAs have it wrong? Of course not. Right, interestingly, the European Data Protection Board, the EDPB, the evolution of the Article 29 Working Party, uses General Data Protection Notice, and again using Wayback Machine in 2018 they used Data Protection Notice. This is interesting for two reasons. First, the European Commission, the CJEU and the European Parliament all use privacy policy. And secondly, the EDPB itself endorsed and adopted the guidelines on transparency under GDPR, issued by the Article 29 Working Party, in April 2018, page 8 of which says, and I quote, "Every organisation that maintains a website should publish a privacy statement or notice on the website. A direct link to this privacy statement or notice should be clearly visible on each page of this website under a commonly used term such as privacy, privacy policy, or data protection notice." So, are these supranational bodies wrong? No, of course not. You can call the document whatever you want. Policy is perfectly good, not only recognised by Europe's top regulators, but recommended and used by them as well. Well, we've looked at the laws, we've looked at regulators, all pretty clear. Let's look at some leading law firms. Now, probably the top UK firm on data protection is Bird & Bird. July 22, they used privacy policy. The firm I started at back in '93, Ashurst, uses privacy policy. Outside Europe, the leading Australian firm Minter Ellison, where I also worked, uses policy, as does the leading US firm Wilson Sonsini, who I've instructed for years. They're fantastic. These are all great global firms. They're not wrong either. Which brings us on to commercial entities. Microsoft used privacy statement. Fair enough. Apple uses privacy policy, and Google uses policy as well. Well, surely ISO itself uses notice. No, uses policy. Well, what about NIST in the US? Well, they use cookie policy and in their footer site privacy. When you click site privacy, you go to a page setting out the information and referring to the privacy policies of other sites you visit and Google's privacy policy. So where did notice come from if it's not mentioned in GDPR and not that many people are using it? Well, in practice, regulators and privacy pros have long spoken about data collection notices, the information you give to satisfy those information obligations. Now, typically it was layered, combining a short, just-in-time notice at the point of collection with a link to your longer privacy policy. But the word notice is just a descriptor of the one or more ways combined in that layered approach in which you give the required information to the data subject. In my 20-odd year experience, everyone in the UK and EU uses policy, apart from a couple of people as we've seen. So in conclusion, if someone tells you it has to be privacy policy for internal and privacy notice for external, they're just wrong. It can be information, statement, privacy, anything you want. So there you are. You know that privacy notice appears precisely nowhere in GDPR, that regulators endorse and use policy, leading law firms use policy, major firms in commercial world use policy, and that nowhere in the world of UK and EU data protection law is there a legal rule about notice and privacy for internal and external use. Now, there may be some domestic national law in some member states. We're talking about EU level and UK law. Now, if you've enjoyed this, you'll love our other provocative video on security. 27001 is not privacy, and we've also got one on 27701 too. And please do use #PrivacyKitchen to tell us the topics and questions you want us to cover. Do visit us at Keepabl.com. Get your demo to see how we make operationalizing privacy simple and intuitive, from data mapping to breaches with instant insights. So stay well in the meantime. We'll see you soon in Privacy Kitchen. You're on notice. I mean policy.